I'm going to start, Mr. Blair. Good evening. I want to welcome everybody to the Freedom of Information session tonight. We all know that transparency and openness is important to the work that we do on behalf of the city. And I want to thank council members and other elected officials and city staff for participating tonight. Tonight, Mr. Russell Blair of the Connecticut Freedom of Information Commission is our facilitator. Mr. Blair is the Director of Education and Communications and manages the agency's training programs, as well as answering questions from state and local officials, journalists, and members of the public. Prior to joining the Freedom of Information Commission, Mr. Blair worked as Director of Communications for Hartford Public Library, and prior to that, spent 10 years as a newspaper reporter and editor in Connecticut at the Record Journal in Meriden and the Hartford Courant in a variety of roles. So we'd like to welcome you this evening, and we're all ears, and I'm just so excited to see so many city staff online. So thank you very much and welcome.
Thank you so much, and thank you for the great introduction. I don't even need to do my little bio there. You had it ahead of time. So again, Russell Blair, Director of Education Communications at the FOI Commission. And really what I do, a lot of people, when they hear about the FOI Commission, it's, oh my gosh, somebody filed a complaint, we have to go to Hartford, there's a hearing, or you hear FOI, I got a records request, oh my gosh, what do I do? There's all these rules, the meetings, hybrid meetings, Zoom meetings, it can be a lot to handle. And my job is really to try to give you guys practical advice, tips, guidelines, so you know what you need to do, you know what the requirements are, and that you can do what's required under FOI, and it doesn't become this big burdensome thing, that you're so worried about. And some of you probably just newly got elected, which is great. You're here, you're at your first council meeting, and then you're going, oh my gosh, there's a million things I need to learn about. So hopefully at least one of those things, FOI, we can make that a little bit easier for you to understand. And then, at the end, I'll give my phone number, my email. Inevitably something's going to come up tomorrow, next week, next month, whenever. Please feel free to reach out. We are there as a resource to help with a lot of these questions. And the tricky thing is I like to always start off by saying I'm not an attorney. Sometimes people think I'm an attorney. I'm really not an attorney. I come at FOI from a journalist standpoint, so I know about it from that. I've studied the law. I work with a lot of really talented attorneys in our office. I've read our decisions. I've watched our commission in action. But I understand how difficult it can be to make those decisions. You're at a council meeting and you're looking at the agenda and you're saying, can we do this? Can we do that? How do we handle all this? And it can be hard. So I say that, not that you're going to leave here as experts in FOI tonight. Hopefully you have enough knowledge that you know what you need to do, when to ask questions, and you know how to handle, the things that are required. Whenever I do a presentation on FOI, I just take a second to talk a little bit about the history of FOI. If you didn't know, FOI became law in Connecticut in 1975. So we're talking almost 50 years that this has been the law. And I like to make a point to say the law, because sometimes people say, oh, FOI, it is the law in Connecticut. So I would hope the same way that you wouldn't, violate the speed limit or, do other things. I would hope that you wouldn't violate FOI. But the difference is that if there's an FOI violation, people, you don't go to the police, you come to the FOI Commission. And basically what can happen is people can file complaints if there's an issue with a public meeting or there's an issue with a records request. They can file a complaint, and then the attorneys in our office will investigate and determine what happens. Was there a violation? Was there not a violation? And then maybe some potential remedies. And what's interesting about Connecticut is we're one of the few states where there is a commission that exists that enforces FOI. When that law was passed in 1975, Ella Grasso was the governor at the time, and she was really the champion of it. The legislature said, this is so important, we're going to create an entirely new state agency, and the only thing that they're going to do is enforce FOI. And the commission still exists today, almost 50 years later, and that's all we do. We just handle concerns and questions about FOI. I always think it's important for people to know a little bit, in the beginning, what is FOI and what's not required under FOI. The name is almost a little bit of a misnomer, freedom of information, but really it's an access law. It's about access to public meetings, and it's about access to public records. We want to see the meetings of our public officials. We want to see the Norwalk City Council in action making decisions, and we want to have the ability to get copies of the records that they're using to inform those decisions. If there's reports prepared for the council, we want to see that. We want to see the budget documents that they're working with. So it's really about access to information. One important thing to know in terms of records under FOI There's no requirement that you need to create records, for some of the city staff on there. You may get a request, somebody says, hey, make me a list. You don't have to make lists, you don't have to create reports, you're not doing any analysis. It's just providing copies of the records that you have as you maintain them. Again, no research and not producing documents that don't already exist. And an important thing for meetings, FOI gives people the right to attend public meetings. They get to attend, they get to sit, and they get to watch. How they participate in the meeting, if at all, that's entirely up to you. Many boards and commissions have public participation, public audience, but it's up to the board how they want to handle that. The council could say it's only, people who live in the city who can comment. You could say people only get 3 minutes or 5 minutes. You could say it's only every other meeting where we have public comment. You can set the rules for public comment, as long as you're not barring anyone from attending your meeting, and the meeting is open. That's what FOI is concerned about. So again, it's really about access. And then another thing, that's sort of one of these things that people think is FOI, and it's not quite. Nothing in FOI requires anybody to answer questions. That one sometimes is surprising to people. You're saying, oh my gosh, if somebody, asks me a question and I work in public works, I can just tell them, oh, sorry, I can't help you. We don't want that. We want you to help the people. You work for the city, I work for the state. When I get a question from you, I try to find an answer. But just know that an FOI request needs to be a request for specific documents. I want a copy of Councilor Smith's emails about the school building project. I would like a copy of the report that was done on the police department and staff, whatever it may be. If somebody says, why did the council do this? Who authorized this? Whose idea was this? Those types of things, you may want to answer them as constituents. You want to try to give them the information that they're looking for. But if someone's peppering you with questions, whether you're elected official or you work for the city, just know, there's no requirement under FOI to answer those questions. If you don't know the answer, you can tell the person, I don't know. You can point them to somewhere where they may be able to find the information. It's only requests for records. When you get a request for records, we'll talk about that later. Those are the types of things that you need to worry about processing under what the law requires for FOI. Sometimes people ask who's covered under FOI. This is a pretty easy one for a group like this. If you're on the city council, that's a public agency under FOI. One important thing I always mention so it's all boards and commissions are covered at the state level and at the local level. You work for the city, your documents are public records. I always like to point out the subcommittees. Sometimes people get tripped up with that. If a council creates a subcommittee, even if it's a limited duration, if you're doing a school building project, you make a school building committee, you have a public works subcommittee, you have a police department subcommittee. Any subcommittee is also covered under FOI. In a second, we'll talk about the definition of a meeting and what we'll throw around quorum a lot. When you create a subcommittee, it doesn't matter if that subcommittee is less than a quorum of your council. When you make a new committee under FOI, basically becomes a new public agency as an extension of the council, and you need to make sure that that committee is also following all the rules. So if you have subcommittees, just make sure that they're, we'll talk later, but they're doing agendas and minutes and everything we talk about, that goes for your subcommittees as well. So next, just going to mention a little bit about the, what constitutes a meeting under FOI? What is the definition of a meeting in our law? And there's a few things there I always like to pull out. So, if you read what the act says, it says, and it's a lot, so I don't expect you to remember all this, but a meeting is any hearing or other proceeding of a public agency, any convening or assembly of a quorum of a multi-member public agency, and any communication by or to a quorum of a multi-member public agency, whether in person or by means of electronic equipment. So a few key things in there. One of them I already mentioned is quorum. That's really, really important. By and large, that is what will make something a public meeting, is a quorum of whatever board you're on. So if you're on the city council, I don't know how many members you have. How many members is your council? 15. So for you guys, 8 is your quorum. So if you have 8 members of the council, math is right. Yeah. If you have 8 members of the council together, and again, that second part of the definition there, whether in person or by means of electronic equipment, if you have 8 members together, that constitutes a quorum. And whether they are in person here at the council chambers, they're at the McDonald's down the street, they're on an email chain, they're on a text message thread, whatever it is, if they're together and they're either communicating or they're discussing upon something that is under their jurisdiction, that's considered to be a meeting under FOI. I'm going to talk a little bit about the email thing, because that's a very common thing that comes up with people. They wonder all the time, what can we do with email? How, does this mean we can't send anybody any email, right? I mean, it's the 21st century. You're telling me we can't use email to communicate. I would lean on that last part of the definition that A meeting is something where you're discussing or acting upon a matter over which you have supervision, control, jurisdiction, or advisory power. So things that are okay for email. Asking to add something to the agenda. You can email all your fellow councilors, hey, there's this project going on. I'm hearing a lot of concern from my constituents. Can we put it on the agenda to talk about it at the next meeting? That's great. You see an article in the hour talking about something going on in the city. You want to share it for your other councilors' information. You can do something like that. Administrative type things. I'm going to miss the meeting. I'm going to be late to the meeting. Those kind of things. Or really a one-way communication. Hey, I've got some thoughts about this project. I'm going to share my proposal with the council, and we're going to discuss it at the next meeting. That's the key thing, is that you can share information, but you want to refrain from back and forth discussions and deliberations, and certainly you don't want to make any decisions outside of one of your publicly noticed meetings. So again, you can use text messages, you can use email to communicate, even if there's a quorum of the board, but you want to really, really limit it, not to very setting the agenda, talking about what may be happening at the next meeting, those kind of things. You don't want to start discussing the topics that are in front of you. So it can be a little tricky, but some people think, oh my gosh, automatically it's a violation if everyone's on an email. It's not. You just have to be careful about the content of that. The challenge, though, if any of you ever worked in particularly like in the corporate world, those emails get sent out to everybody. Somebody starts hitting reply all, and then it turns into this whole tangent about whatever the topic of the email was. So that's the challenge with sending an email to an entire board or commission, is you don't want people to start replying all and starting to continue that discussion. If somebody wants to add something to the agenda, that's great, but you want to save the discussion for the next meeting. And I'll talk about this too. We were mentioning earlier, devices. We'll talk about this more in records. But what makes something a public record in Connecticut, the way it's structured in the FOI Act, is the content of the public record. So when we're talking about emails and text messages, it depends what the content is, not what the device is. So, if you think, oh gosh, if we all are on our Gmail accounts and we're emailing each other, well, that's not our official Norwalk account, so that doesn't make it a meeting. The answer, that's wrong. It would depend on what the content of those, what those messages are. So you want to be mindful of it, because again, that piece about electronic meetings, but just know it's not automatically going to be a violation if there's an email between the whole council. It depends on what the content of that email is. We'll talk a little bit about some of the other ground rules for meetings. As I said earlier, anyone can attend a public meeting. You can't bar somebody if they come from Bridgeport and they want to come to the Norwalk meeting. You can't tell them to get lost. As we said, you can set your own rules for public comment. Anyone can photograph, record, or broadcast a meeting. I always say I would hope that you never say anything at a council meeting that you wouldn't want somebody to record and play back later, but just assume that, even if the city's not recording the meeting, somebody in the audience could be recording it, and they don't need to tell you. They don't need prior permission, as long as they're not being disruptive, that they're allowed to record the meeting. So the law allows for 3 different types of meetings. There's regular meetings, there's special meetings, and there's emergency meetings. So start with the most basic one, which is regular meetings. Every board and commission in your city is supposed to file with your city clerk at the end of January a schedule of regular meetings, and that's going to say, we meet the second Tuesday of every month, we meet the first Wednesday of every month, whatever it is. That's your regular meeting schedule. I see you've got the presentation up, so I think we're on meetings. What is the Freedom Public Agency? We talked about that. Some of these questions. What is not a meeting? What is okay? So this is kind of where we are right now. So I don't know where you want to go. No, it's okay. Maybe we do this and then we do the question slide after. You want to do that? Okay, so this is some of the things that we're talking about right here. But let's go first. We'll go over some of the types of meetings. So regular meeting is just on your regular meeting schedule. You file it with the clerk. A special meeting is just any meeting that is not on your regular meeting schedule. Sometimes people see special meeting. I think you guys even noticed tonight it's a special meeting of the council, which is great. A special meeting is just any meeting that's not on your regular meeting schedule. 2 important things to know about a special meeting is, first of all, you can't add any items to the agenda at a special meeting. If you're ever at a regular meeting, you can see it right here. You can add items to the agenda at that meeting by a 2/3 vote. But in a special meeting, can't add anything to the agenda. So whatever's on the agenda for a special meeting is what you're taking up that day. What I always tell people is, if you're preparing the agenda for the special meeting, make sure you check with everyone, get everything on there. In the event that you had extra time, you finished your work early, you can't move on to something else if it hasn't been put on the agenda for a special meeting. And even the name special meeting sometimes is a little misleading. People think, oh, it can only be for a certain topic, and that's not the case. Anything you want to do at a regular meeting, you can do at a special meeting. The only thing that makes it special is just the fact that it's not on your regular meeting schedule. So if you want to have a special meeting, a notice and agenda are required 24 hours in advance. You post that on your website. For regular meetings, the agendas need to be filed 24 hours in advance. The rules for posting things online at the municipal level are a little bit different than the state level. I think most cities and towns now will post agendas online. But for a regular in-person meeting, if there's not a Zoom component, legally, the agenda doesn't actually have to be posted online. I would strongly encourage that you do post them, because I think people look for them online. If they don't see it online, they're going to think something's wrong. But just know what the law says is it needs to be filed in the city clerk's office. I did a training last week where this came up, and they had an issue where it was posted online, but it wasn't filed in the clerk's office. And even though people saw it online, by the statute, that was a violation. That was an error. It needs to be, make sure that the agendas get to your city clerk and that they're there 24 hours before the meeting. So we talked about regular meetings and then special meetings. The third type of meeting in the law is what's called an emergency meeting. And you don't see these too frequently. And, as the name suggests, this is something that, is only in the event of an emergency. It's a meeting where you can't wait the 24 hours to call that special meeting. If you have an emergency meeting, there's no notice or agenda. So, this is going to be something that immediately is going to kind of draw suspicion. So you really want to be, judicious in how you use emergency meetings. You can only consider the emergency matter at hand. So if you have an emergency meeting, you can't start moving on to the budget or other things that you want to work on. It's only for that emergency. For regular meetings and special meetings, your minutes need to be filed within 7 days. For an emergency meeting, they need to be filed within 72 hours. So a much shorter turnaround there for emergency meetings for the minutes. And for an emergency meeting, the minutes need to be posted on the website. A very common thing I get calls about all the time is other meetings, regular meetings, special meetings. Do the minutes need to be posted on the website within the 7 days? Again, it's kind of like the agenda. They need to be available, is what the statute says. So you need to make sure that whoever on the commission is doing the minutes, or the clerk, or whoever it is, recording secretary, they get them to the clerk to be in the office within the 7 days. If it takes them a couple days extra to post them online, they're not online until 10 days after. That's not a violation. They need to be in the office. But again, this day and age, people look for them online. So I would say if you can get them online within the 7 days, it's all better, because if people don't see them, they're going to call you up and they're going to say, what's going on? Where are they? And then you're going to have to track them down and email them. So if you can post them online ahead of time, that's even better. So back to emergency meetings, there's one story I always like to pull out for this to talk a little bit about what the commission can do. What are some of the powers of the commission? You may be sitting here thinking, gee, this is all great, right? But what happens if we mess up, right? And we get in trouble? What do we do? Well, the commission tends not to be very punitive. A lot of times, if any of you ever look at our decisions, if we find a violation, it's basically, we tell the agency, hey, you made an error, do better next time. In some cases, if we think that there's, kind of a bigger misunderstanding or confusion, we may say, we'll order a training session, right? There was an error, Russell's going to come down and do a training session. We're going to talk about what happened and address any questions people have. On records cases, we can order the production of documents. The city says, gee, we don't think we have to give this out, goes to the commission says, no, you do. We can force the city to release documents. In a meetings case, what can happen is, in certain instances, the commission can come in and say, that meeting was improper. Let's say, no agenda was filed, somebody was barred from attending, whatever it may be. The commission could say, that was an illegal meeting. Anything that was voted on, any action taken at that illegal meeting is null and void, and you basically have to go back and do it over again. And there's a story that's sort of a once in a lifetime thing that happened, but it just goes to that point. So this is now going on about 15 years ago. And this was the case that sort of set the Supreme Court precedent for emergency meetings. And to make a long story short, what happened was there was a town where they had a fire chief was retiring, and the first selectman went to the deputy fire chief and told him, okay, you're going to get the job. And the deputy fire chief was excited. You know, he had been working in the department for a while, and he was happy about the news, and he starts telling people and all this. But, you know, for some reason, I guess the first selectman hadn't checked with his other colleagues, or he was having second thoughts. And so after they told him initially that he was going to get the job, they had the uncomfortable position of having to say, well, actually, we're going to go into a different direction. And as you can imagine, he didn't take the news very well. And it sort of blew up, and there was shouting and there was yelling. And it became this big thing, and other people in the town hall could hear it and all this. And the guy stormed out, and he was not very happy. So other people in town hall told the first selectman, you know, you got to do something about this, right? And he's your employee, he's being insubordinate, things he said wasn't appropriate, he didn't handle it properly. So instead of calling a special meeting to deal with it, if they thought the whole board of selectmen had to, you know, weigh in on this, they could have called a special meeting. For some reason, they decided to have an emergency meeting. They said this, you know, firefighters insubordination is so important that we have to have an emergency meeting. So they called an emergency meeting, and my understanding is that, you know, it was the next day, and I think it was a weekend, it was like a Saturday morning. So they go to the guy's house, and he's raking leaves in the yard, and they say, hey, come down to City Hall, we're having an emergency meeting to talk about what happened. They had the emergency meeting, nothing really gets resolved, it's just more yelling and accusations and this and that. And then at the end of the emergency meeting, the deputy fire chief leaves the meeting, and, you know, if you talk to him, he'll say he resigned. If you talk to the town, they say that they terminated him. Regardless, at the end of this emergency meeting, you know, he's no longer employed by the town. If any of you are ever on the losing end, or sorry, to jump ahead for a second. So he files a complaint with the commission, as you can do, right? You know, he maybe learned about the meetings rules in one of these trainings. Maybe he talked to an attorney. He filed a complaint and said, look, I don't think that was an emergency meeting. So it goes before the commission, and the commission agreed. And they said, yes, this personnel issue is not grounds for an emergency meeting. So if any of you are ever on the losing end of an FOI decision, you know, we come out and we say you were wrong, and you really disagree, and you think, no, I really think they got it wrong, you can appeal our decision in Superior Court. You basically sue the FOI commission. That's what happened in this case. The town sued the FOI commission, and they said, no, we think that that was a grounds for an emergency meeting. They lost in Superior Court, went all the way to Connecticut Supreme Court, and all along the way, the court said, no, that is not an emergency meeting. It's, you know, somebody's personnel issue is not grounds for an emergency meeting. You know, if any of you follow the courts or anything, you know how long it takes to go from a decision at the FOI commission all the way to the Supreme Court. You know, it's a span of 2 or 3 years. And if you remember what I said earlier, the FOI commission can say actions at that meeting were null and void. So all of a sudden we were in a situation a couple years later where this guy had not been getting paid. He'd been taken off the payroll, and the Supreme Court said, no, that never happened. So all of a sudden, after losing at the Supreme Court, the town next had to figure out how much money they're going to pay the guy. They're going to negotiate a settlement with him so he doesn't go and sue them for all the back pay that he was owed. So again, that's a once in a lifetime type of story. Probably is never, ever going to happen again. I hope to God it never happens again. But I share it as just sort of the extreme example of what can happen. You would hate to put a lot of hours and time and sweat and blood and all this into a big project, and then the agenda doesn't get filed in time, and you just say, well, we're just going to go forward anyway. And have something like that happen. Again, the chances of that happening very, very small, but I just say it because it is kind of the extreme example of what potentially could happen. So, you know, when you're dealing with your meetings, when you're making sure you get agendas in on time, you know, that's sort of the most extreme risk that you run. So you really, really want to, you know, make sure that the agendas are in on time. You know, I understand things happen. I get calls from clerks of boards and things. Somebody was sick and we didn't, you know, we didn't get it in on time, or, you know, I forgot the town hall was closed for a holiday and I brought it in the morning of the meeting. Is it okay? And I have to tell them, no, it's not okay. And at that point, really the best thing you can do is, if there's an error like that, you know, cancel the meeting, schedule a special meeting for, you know, later in the week or something like that, you know, maybe, or find a date where people are available. It may be frustrating, but, you know, really, if there's an error like that and you catch it, you want to try to take some kind of action. How do you want to do the presentation? You want to just go through it? Okay. All right. So the next thing we're talking a little bit about is electronic and remote meetings. So this is a newer area of the law, and there's a lot of you can leave that up because that's where we go to next, is executive session. So electronic remote meetings. Again, newer area of the law, and there's a lot of different quirks here. We're going to cover the major things you need to know. but happy, at the end to take questions about this. So, I mentioned the definition of a meeting earlier. I talked about it, and there was that piece in there about electronic equipment. So during COVID, there was an executive order that was put in place, and the executive order allowed boards and commissions to meet over Zoom, and it set out some ground rules. And then the legislature, a couple years after that, in 2021 and then 2022, passed some laws that basically set the rules for how to run these meetings. So a couple things to know. If you have a regular meeting, either people use the term hybrid, which is actually not in the statutes anywhere. The way that we call it, the way it's defined in the statute is if you're using electronic equipment. So if you have a meeting where there's a Zoom piece and there's an in-person piece, and it's a regular meeting, or if you have a regular meeting where it's online only, everyone is on Zoom, and again, regular meeting. In that case, the agendas are always 24 hours in advance, but 48 hours ahead of time, ahead of the meeting, you need to post on your website the link that people can access that meeting. How can people log in to watch the virtual meeting? I've seen some towns where, and I'm not an expert in Zoom, but if you have the capability to do this, it might not be a bad idea. If you know the dates of all your regular meetings, you can go in and generate the Zoom links ahead of time, so that you could post, the links for the year, the links for the next month, or, whatever it is, so that every single meeting, you're not rushing to have to go and post those links. Because the agendas are always 24 hours. It's just the link that needs to be available 48 hours in advance. Again, I've seen some cities where they just, the whole week's meetings, they post all the Zoom links at the beginning of the week, and they're all set. And then the other question I get a lot of questions about is, recording meetings, right? Do we have to record the meeting? Do we have to post the recording of the meeting? How long do we have to keep it? How does all that work? So the only meetings by statute that you need to post recordings of are meetings that are entirely virtual, entirely online, and a regular meeting. So if you have a regular meeting of a board or commission or your council, and it's entirely virtual, in that case, you do have to record the meeting, and then you post the recording on your website within 7 days. So the same time frame about the minutes we talked earlier, minutes go within 7 days. If you record a meeting, recording gets posted within 7 days. And then you have to leave that on your website for at least 45 days. So recording up within 7 days, keep it up for at least 45 days. You always do minutes, even if you have a full recording of the meeting, the minutes are still required. If you record your meetings, then, maybe you can keep your minutes briefer. You don't get into every single point that was made or all the, rehash everything in public comment if you have a full recording of it. But just know minutes are still required, even if you have a recording. And then another thing I wanted to talk a little bit about, and my understanding is some of this has happened recently, is some cases, we get like the keyboard warriors, right? We get these people who they come in the online meeting and they sort of, because it's a little bit more anonymous, because they're not there in person, their behavior is worse, right? They're in public comment, they're going on and on, they're going past the time limit, they're interjecting during parts of the meeting that they're not supposed to participate in. Or this is, not so much of that, but the classic, they leave their microphone open and the radio's blaring and you guys can't hear what's going on. The rules for online meetings in terms of like decorum and how people need to behave are the same as in-person meetings. So in the same way, if somebody's making comments that you wouldn't allow in an in-person meeting, somebody's being disruptive in an online meeting, you can kick them out, you can mute their microphone, you can take steps to resume order in an online meeting. I know sometimes people get nervous, oh my gosh, I kick somebody out, it's an FOI violation. If they're being disruptive, if they're preventing you from doing the work that you need to do, it's the same, handle it the same way that you would as, as an in-person meeting. You ask them to leave, please leave, please leave. And in this case, you're not calling the police or whatever, but you're just kicking them out, kicking them off the screen. You're not violating anyone's FOI rights. If you exclude them from a meeting, if they're being disruptive, and that they're not allowing you to do their work. Anyone have any questions on any of the stuff we covered so far? Electronic meetings or agendas, anything like that?
Whether or not it's required.
Sure. So there is no requirement for public comment. It's entirely up to the board or commission how you want to set the agenda. What I've seen some towns do with public comment for online meetings is, you could have a sign-up sheet ahead of time. You could ask people to send in, if they want to participate in public comment, and you can send them links. And then that's the point you have right there is that, yes, if you have to keep it equal though, if you have hybrid meetings and people in person can comment, you have to make it, make a way that people can do it, in the virtual setting. But it's not, required. If you want to say no public comment, you can have no public comment. What's interesting about that is, there was a bill in the legislature last year where they would have actually required public comment at every meeting. Thank you. And, there was a little pushback, as you can imagine, from, some of the smaller boards and commissions. It's funny, if you think of it, think of it to its logical end. I mean, if tonight is a special meeting of your council because there's a quorum here, we would have to open this up to public comment if someone wanted to come up here and tell me, how wrong I am about FOI or something. So, just be on the lookout for that. But as of now, there's no rules, mandating any kind of public comment. It's entirely up to you guys how you want to handle that. Except the allowing it with the, is that what you're gonna say?
No, I was gonna say, if you have a statute that requires you.
Yes, if you have a, is that the case here? Do you have a?
Yeah, so
Yeah.
if you pass an ordinance here, there's an ordinance that requires you to have a public hearing. Then there's a state statute that requires a public hearing if you sell a city-owned property, real property.
Yeah, the challenge with some of the FOI is that, everything we're talking about today is kind of is like the bare minimum basics. And then there will be other cases other things that will apply depending on the case. For example, if you have a planning and zoning commission, there's additional requirements in the planning and zoning statutes. That, for example, we talked about recording meetings. I didn't mention this, but planning and zoning, there's an additional requirement for audio recordings of meetings. Because if you deny a site plan and somebody wants to appeal it, they have to go to Superior Court. The judge wants a transcript or recording of what happened at the meeting. So everything we're talking about today is sort of the bare minimum basic level, but there certainly could be additional things. To your point, governing documents, some places have charters that say you have to have public comment, or you guys may set a council rule that, dictates what needs to be done. So you can have all those rules and they can be stricter and require it, but, basically with, as we talk about records later, you can't have anything that's in conflict with FOI. You could have a stricter requirement. We'll talk about timeframes for responding to FOI requests. The city could have a policy that you need to respond faster than what the law requires if you want. So you can always be stricter, but you can't have anything that is, goes to contrary to FOI. So the next thing I want to talk a little bit about is executive session. So if you want to put back the slide that we had on that. So what's important to know about executive session is executive session is, as you see in all these things, it's for discussion. You should not be voting in executive session. You need to come out and take your vote in public, but executive session allows for you to discuss certain topics, with the public excluded. They don't get to be there to listen in. What's important to know is that, as I said, the law is really specific. Sometimes people think executive session means, we want to talk about a controversial thing, right? We're uncomfortable having a public discussion. Again, I had a call last week from somebody where, they said, well, our auditor doesn't really feel comfortable presenting the audit in public. Can we do it in executive session? We're going to release the document anyway. It's a public record. And I told them, no, talking about an audit is not, what you'll see there. It's not one of the reasons to have an executive session. So it really needs to be limited. The first one on there is what we call the personnel matters executive session. And in this case, you're talking about, it could be for hiring. It could be a performance evaluation of a public employee. It could be, a disciplinary matter, firing an employee. The idea there, personnel, is you're talking about an employee, not personnel issues like budgets or staffing or uniforms for the police department or things like that. If you have an executive session for personnel matters, it's important that you notify the person who was the subject of the executive session, because they have the right to demand that be held in an open session. You may be asking, gee, why would somebody want their sort of dirty laundry aired out like that? But sometimes what happens is, people could be accused of something. They strongly believe they did nothing wrong. They may say, look, let's have it at a public meeting. I want my friends, my family, my coworkers, I want them to be in the audience. I want them to hear this. Or, you're evaluating your police chief and everyone thinks he's doing a really great job. And he says, hey, let's do it in public, right? I don't have anything to hide. I'm happy to answer questions. I want people to hear what you guys think about me. So in the event that happens, if somebody requests a public session, your hands are tied. You have to do it in a public session. Second item on there is strategy or negotiations related to collective bargaining. Strategy negotiations with pending claims with pending litigation. The important thing with pending claims and pending litigation is that it's meant to be when there's actually either something has been filed, there's been a lawsuit that's been filed, there's been an FOI complaint that's been filed, or you've received a demand letter. Somebody tells the council, if you don't do this, I'm going to sue you. The city gets something, from an employee. I think you've done this, and this wrong. If you don't give me the settlement, I'm going to take you to court. Anything like that is considered to be a pending claim. And with that, you can go into the executive session to talk about your legal strategy. If you're discussing, settling a lawsuit, you don't need to do that in the public portion of your meeting. The third reason for an executive session is for security matters. The idea here is that if you feel the discussion, having it in public would hamper whatever it is you're talking about. If you're buying a new security system for this building and you want to have a discussion about, where the security cameras are going to go, or you're talking about installing panic buttons in the council chambers, those could be things that you wouldn't want to have a public discussion about, because you wouldn't want somebody who may have nefarious ideas to hear that and learn about your security system and potential vulnerabilities. With that, I always point out, again, this is for discussion. So when you vote to appropriate the money to buy the system, that obviously would need to be a public vote. Next reason for an executive session is to discuss sale or lease of property. And the idea here, again, is that there's going to be, in this case, it's not a security issue that would be compromised, but it could be that the price of that transaction could be compromised. Maybe the town is looking for a site for new recreation fields, and you find a piece of property and you're prepared to offer up to $500,000 for the piece of land. You may not want to disclose that publicly, because maybe the property owner would let it go for half that, and finds out all of a sudden that you have a budget of $500,000. Surprise, surprise, he's going to come in and he's going to say, well, I'd like $500,000 for the land. So if you ever have an instance like that, talk about the sites in the sale or the lease in an executive session. And again, you vote in public session once you want to purchase the property or to sign the lease. And then the last reason for an executive session is really the broadest. And basically what this says is that you can discuss any records that would be exempt from FOI. So any records that you wouldn't have to provide via an FOI request, you can discuss those in an executive session. We'll go through the exemptions in the second part when we talk about records, but a couple common things that will come up with that. There's records that are protected by attorney-client privilege. If the council wants to get a legal opinion from the city attorney, or from the council, if you have your own attorney for the city council, you send them an email, please send me your legal opinion of this topic. That email they send back to you is protected by attorney-client privilege. And if the council wants to review that document in executive session, they could do so. Another common one is when you're dealing with bids. There's an exemption in our law that says before you sign a contract or you end negotiations, whichever happens first, you don't need to disclose the contents of the bids or responses to an RFP. So the council can go in, you guys could review the responses to the RFP, you could discuss them, what you like, what you don't like, what you're thinking, before a contract is awarded. Once a contract is awarded, then the bids are public and the discussion would need to be public. But until you award a contract, you could have that in an executive session. So again, that item E on there is really the broadest. So when we're talking about records later, just think about that. There could be certain records that we talk about that may be permissible for an executive session. If you have an executive session, you need to vote by 2/3 to go into the executive session. So make sure when you're at the meeting, if you're doing the minutes, make sure that there was a vote to go in. You reflect that. Even if the only thing you're doing at a meeting is having an executive session, it's still a public meeting. You still need an agenda. You still need minutes. The public is still invited, even if they walk right in and you tell them they got to leave. You shouldn't adjourn a meeting from an executive session. You should come back out to public session, even if it's just for a minute to just adjourn it. You need to make sure that you do that. As I said, no voting during executive session. Oftentimes people ask who can come into an executive session, who's allowed to be there. It's really up to the board who they want to have in the executive session. The key thing is that you want anyone in the executive session, you want them there for a particular purpose. They're giving testimony, they're giving their opinion. You're discussing the legal memo with the city attorney. You need people there, as I said, to testify or to give opinion. You want to avoid what we call creating a second audience. You don't want to just have people that are sitting in the back of council chambers and they're just listening and they're not really participating in the executive session. Because if that happens, somebody could come along, they could file a complaint, and they would allege that, that person got the right to attend the executive session and I did not, right? My rights are being infringed because they got to attend, and I did not. So as we said, 2/3 vote to go into executive session. And then agendas for executive session. This is a really, really important thing. I want you to know if you're ever preparing agendas for executive session or you're thinking about executive sessions when you're on the council, you don't want to just state the reason for the executive session. One of the ones I talked about. You don't want to just say executive session personnel matters. You don't want to just say, as it says there, executive session to discuss litigation. The way to think of it is the public doesn't get to attend your executive session, but they have the right to know the topic that's being discussed. So in the case of a lawsuit, put on there, executive session to discuss, pending claims or litigation involving the Jones lawsuit. They're not going to know. It's a publicly filed lawsuit. It's, it's public information. It's been filed. They're not going to know what you're talking about if you're talking about a settlement or if you're talking about, witnesses to testify at the trial. Could be anything, right? But they need to know you're talking about that lawsuit. And the same thing with personnel matters. You don't want to just say executive session personnel matters. If you're talking about the conduct of police officers, executive session discussion of the performance of a police officer, executive session, evaluation of the police chief, things like that. If it's not a, department head or, somebody of that level, you don't need to name the person. You don't need to say, discussion of the performance of Officer Smith. You don't need to identify them. You don't have to go that so far as that, but you do need to give people an idea of what's being discussed. And again, they don't get to know, what the discussion is, but they need to know the topic of what's being discussed. Any questions on, here we go. Let's see here. So this is a good point here about executive sessions. So the executive session is basically allowing you to meet in that session, and you're not in violation of FOI laws. But any records that you create during an executive session, it could be public records that would need to be disclosed. For example, if you're in the executive session with your fellow counselors and you're talking about something, controversial and all this, and then you come back after the meeting and you go home and you write up a big email and send it to all the other counselors, recapping everything that happened in the executive session, that could be something somebody could FOI, unless there was another exemption that applied that we'll talk about later. That would be a public record. So you want to be careful if you're in an executive session. There is an exemption in the law for personal notes. So if you're writing down things to kind of aid your memory, that may be okay, but you really want to be careful. Records that you create reflecting the executive session are not going to necessarily be privileged. The privilege is that you guys get to go in and have that discussion. It's not that if you create records, that they're exempt from disclosure. In this case, can they both terminate the officer in executive session? Everyone, no, you got to vote in public session. Any questions on executive sessions? Okay. You have the one about what is not a meeting? I think that's next. Let's see. Okay. So let's go through some of these questions. Let's see if we can get a little audience participation. So you all decide that you love this PowerPoint presentation and request that I disseminate a copy to you all via email. Is that a violation of FOI? Any guesses? Answer? What do you want to see? No. So as we talked about, it's not, if it's an email and it's not, discussion or action, then it would not be an FOI violation. If you guys started talking about setting policy for the council on FOI and what you wanted to do, that could be an issue, but just sending it would not be. So this is one that comes up pretty much, I would say, every year with boards of education. A lot of times they like to do these retreats where they talk about the budget. So in this case, you guys want to have a retreat to discuss issues, policy matters of interest to them. You want to invite your state senators, state representatives. Is that a public meeting? Yes, yeah. If a quorum, if the whole council is there, that's the thing that makes it a public meeting. So if it's a quorum of the council and they're there, you're inviting in your state representatives. And this is the key thing in there is that if a quorum is not present, so if you have a couple members of your council and they want to go meet with a state senator and it's not a quorum, that's not a problem. The problem is if you have the whole quorum of the city council there.
And bullet point number 2 is wrong. It's actually yes, even if it's not a caucus.
Yeah, so we'll talk about caucus in a second, but it needs to be, caucus needs to be same board and same party. I might as well talk about it now because we're there. So, you know, caucus, again, it's the Democrats on the city council. You know, it's Republicans on your board of education. In some instances, you can have a caucus of people of different parties. If that's the case, like let's say you have an independent who caucuses with the Democrats. What the law says is that they're supposed to file something with the city clerk that says, you know, for FOI purposes, I am a member of the Democratic caucus. So even if your caucus, and I think that's the case in the city here, even if your caucus is a quorum, or more. So I think that, right, you guys have, it's like mostly Democrats, and if they were 1 or 2 others, 1 other. So everyone except that one person is a caucus, and even though it's more than a quorum of the council, it's not a meetings violation for all the Democrats on the council to talk amongst themselves. But that's the key thing, is really amongst themselves. You should not be bringing people into the caucus with you. You know, your party chairman should not be there unless they happen to be on the council. You know, you shouldn't be, you know, having a caucus. Again, it's really for the members. If you think back to when the law was passed, the legislature put this in there for themselves because they said, gee, you know, we don't want to have to open up our caucuses to the public. So at the local level, sometimes it gets a little different. But kind of like what I said earlier with the executive session, just be mindful that any records that you create out of a caucus are not necessarily going to be privileged. So same idea that, you know, the Democrats on the city council are talking amongst themselves. You could argue, okay, it's not an illegal meeting because it's a caucus, right? Let's say we want to say we have all the 10 Democrats and they're emailing amongst themselves, but we're going to say it's a caucus. Even if that was, you know, even if it wasn't a meetings violation, even if we said, yeah, that was a caucus, the records that you created are still public records. So if you're in caucus, you want to be mindful, again, kind of like the executive session, you go home, you type up everything that was discussed in the caucus. You know, there's no privilege to that information, to the record you created. It's just allowing you to meet, you know, in that meet in that setting, even though it's you know, a quorum of the council. And then we've got Pam Public is addressing the council during public comments. 6 council members are texting about how ill-informed and mistaken her observations are. They're insulting her wig. Is this a meeting? And the answer there is no. If they're not, you know, if it's not a quorum, it's not an issue in terms of meetings. But again, those are public records. So if Pam Public wants to FOI, you know, what the people are texting about her, you know, they would need to provide those text messages. Yes.
Wanted to think a question that's come up multiple times every year. So, your position is no one should be in a caucus who's not a member of that body.
So we've had cases where there's like 2 sort of outliers. There was one years ago in Danbury where it was like a television reporter was in the caucus filming it. Someone filed a complaint, and the commission said, well, they weren't really participating. So, you know, I think that there's a couple where it's like someone was there, fly on the wall type of thing, but by and large, if they should not be participating. You run the risk of somebody filing a complaint, and we have more decisions that say that someone cannot be invited in. And again, that one is like the outlier. So I can't say it's never been okay, but I think there's one, and then there was like another one. I can't quite remember where we said it was not quite, but by and large, it should be same board, same party. If you do that, you know, you're okay. You want to be careful about other people coming in. Yes.
So there was one particular case where I think it was a superintendent of schools walked into a meeting and provided notes for a case. I think she gave information to someone on board at a caucus. And the commission determined that that was not a meeting because the conversations were essentially, you know, greetings and salutations and not discussions that were pertinent to whatever was happening, and they left immediately after.
Yeah, that was sort of the same thing with the TV one from my recollection, is that because they were just sort of there, like, you know, recording it for whatever, it wasn't, you know, but you don't want to bring them in and start having them participate. You don't want your town chairman there talking to all the city councilors about, you know, what you're going to do at the council meeting. Yes.
I just want to ask a little more.
Sure.
So say there's a new employee been brought on staff, and would that person be able to attend, introduce, we've got questions, and then they leave?
I would, a couple things. I mean, I think one, I think if you really felt like you had to do it privately, maybe it's a personnel executive session. I would also argue, could you just do it with the whole council, in the public meeting? I mean, the other thing that, where that may fall into is that, do you have the other slide, the list of what's not considered meetings or the non-meetings? There's also an exemption for what we call a chance/social meeting. So that's basically when you have a quorum of the council together, but you're not discussing council business. So that may be what this could fall under, right? It's, if it's, the person is just there, you come to City Hall and you say, hey, this is our new purchasing director, you meet them, great, this is where'd you go to school? Oh, my son goes there, blah, 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 blah. Where you're not really talking about city business. But that's the thing with a lot of this, the challenge always is you really have to be careful because you don't know where it's gonna, morph into. If you start asking questions about, well, what is your thinking of the direction of the department? What would you like to do? And, this sort of thing, it can get more towards, that meeting territory. So I would say that, to the last point on there, that's a key thing too, is that, are you discussing or acting upon something that you have supervision, control, jurisdiction, or advisory power over? So sort of pro forma, hello, hi, how are you? That may be okay, but you would really need to be careful that it doesn't start moving into, talking about their position and what they're doing and goals and that kind of. Yes.
I'm just gonna fix from someone online that just requested if we ask any more questions, if we repeat them, the online.
Oh, sure. Yeah. So that was about what was the question?
You answered it, thank you.
Okay.
Yeah, you mentioned that.
Oh, all right. So there's a couple other, so we talked about caucuses, and I just talked about, chance or social meetings. There's a few other things, in the law that, that are not considered to be meetings. If you look at the definition of a meeting, there's these other things afterward, that are, where it says basically these are carve-outs from the meetings requirements. One of them is that any board or commission can create a personnel search committee for an executive level employee. So, let's say your school board is looking for the next superintendent, they can create a search committee. And then that search committee, as you see here, that search committee, when they're in the search committee mode, they're not, they don't need to do agendas, they don't need to do minutes, they don't need to notice their meetings. So if they want to review resumes or they want to interview candidates for, the position, they can do all that outside of FOI. And they would, however, have to return to a public meeting, to vote on hiring the superintendent, but it allows for that search committee to work outside of FOI. We talked about the chance or social meeting. One piece of advice I always give boards with that is you really want to try to avoid what I call the parking lot meeting, which is have your city council meeting, and then afterwards you're standing out in the parking lot, you're talking, and you're, maybe you're just blowing off steam, and that's okay. Oh my gosh, I can't believe that we're spending 2 hours on this. Geez, what you want to avoid though is you want to avoid starting to continue the discussion of what you talked about at the meeting, outside of the meeting. So, if you want to go out to get a drink after the meeting, that's fine, but you don't want to just start continuing, the projects and things that you were talking about at the council meeting. You want to find, something else to talk about. We know what's going to happen. We know you guys spend a lot of time together working on city issues, but you don't want to do the work that you would do at the council meeting, in one of those social settings. Strategy or negotiations related to collective bargaining. So anything with collective bargaining, if the mayor wants to come in and give the council an update on where things stand with union contract for town hall employees, they could do that outside the meeting if they wanted to. It's not considered to be a public meeting if it's just limited to that. Caucuses we talked about, administrative or staff meetings. So a meeting of Norwalk City employees is not a public meeting under FOI. And then the last one on there we kind of touched on earlier, which is, if you're just sending out the agenda to everybody, that doesn't constitute a meeting. We already talked a little bit about, email and meetings. And again, I'll make the point about personal devices, personal emails, all that. What determines, if it's applicable in terms of whether it's a meetings violation or whether it's a public record is the content of whatever it is. So if you're sending emails about your city council business from your personal email account, that in and of itself is not an FOI violation. Sometimes people think, oh, if we use a personal device, we're running foul of FOI. So that in and of itself is not, they're running foul of FOI. But what you want to be careful with is that if somebody makes a records request and they want, all of your emails on a certain topic, if you use 2 email accounts, then you may be in a position where, you're having to search through your Gmail account and trying to find things. And, maybe you delete all your emails every week in your Gmail account. And now you're trying to figure out, do I still have it? So it can be, it can cause some headaches when it comes to, if you get an FOI request, if you're using personal devices. Again, it's, you can use them, it's okay, especially cell phones. The city, I imagine, is not paying for all you guys to have personal cell phones. So you're going to be using, pay for work phones. So you're going to be using your personal cell phones, inevitably to text about city business. That's not the concern, but the concern is, if somebody makes an FOI request, you may have to go and retrieve any messages that you have that are on your personal device or documents that you created on your personal laptop. That was during COVID. That was a big thing. People asked a lot about, I made this presentation at home. Is it a public record? If it pertains to the city's business, it's a public record. So the last thing I want to cover with meetings is minutes. Most important thing is, the minutes need to be filed within the 7 days. They don't need to be super long. If you have a 15-page, we may applaud you on your 15-page minutes, but if they're filed 2 weeks late, that's what we're concerned about. So get the minutes in on time. Sometimes people ask about, approval of minutes. Gee, the council doesn't meet for a month. What do we do? Right? They need to approve the minutes. You have to submit the minutes within 7 days. If it makes people feel better, you can call them draft, you can call them unapproved. If there's changes to the minutes, you can reflect that in the minutes of the next meeting. So if people are following along, they can see that there were changes made. But the minutes need to be in within the 7 days. The only requirements that you need to have in the minutes, where and when the meeting took place and who was there, and then any votes that were cast. And then if you have an executive session, you list who attended the executive session, but you can exclude any job applicants. So if you're searching for your police chief, and somebody's working, at another department in the state, you don't have to out them that they're hunting for a new job. But anyone else in the executive session, you need to list that in the minutes. And as I said earlier, minutes are still required, even if you have a recording of a virtual meeting, you still have to do the minutes. I do the minutes for our commission meetings, and we keep them pretty brief because we record the meeting. So if somebody wants all the detail about what happened, they can go to the recording. Nobody has a right to attach anything to the minutes. That's a thing I see sometimes. People will say, well, I handed the document over the counter to the city council at the end of the meeting, and I told them to attach it to the minutes, or they spoke at public comment and they expect to see their name and their address in the minutes and what they said. All that is within the purview of the council. How much detail you want to put in the minutes is up to you. But what's not up to you is you have to get them in on time. So, detail is good. You want them to be a little bit more than just the votes that happened. But you also don't want to be late in filing them. So you want to make sure that you get them in on time. Any questions on minutes or emails? Yes.
Is there anything else that's not?
The question was, is there anything else that's not FOIable? So we will talk about that in the next piece with the records exemptions, but we will get to that.
If you have a regular scheduled meeting and the location, the room, for example, is now no longer available, and you have to move that meeting to the next day or the next week, does that meeting now become a special meeting, or can you still categorize it as a regular meeting?
So there's 2 ways you could handle that. The first is you could just cancel it and then schedule a special meeting at a different, do the 24-hour notice and post it on the website, or the law allows you to adjourn a meeting to an alternate location. So in this case, if you wanted to keep it as a regular meeting, you could adjourn it to a future time and place. If you do that, and this is where FOI gets a little quirky because some of the statutes are really antiquated. And in this case, the statute says you have to post a physical notice. So if we were, if this meeting was supposed to take place in this room tonight and you wanted to move it to a different room in 2 days, on the door of this room, you're supposed to post a notice that says, tonight's meeting has been adjourned to, Thursday at the Board of Education building or whatever it is. So you can do that, keep it as a regular meeting, or you could cancel it and schedule a special meeting, however you want to handle it. Any other meetings questions before we move on to records? we can come back at the end if people think of any of that. Okay. The most important thing I think to know when it comes to public records in FOI in Connecticut is the definition of what's a public record is really quite broad. You know, if you're coming from the private sector, it may be a little bit surprising to you. But what the law says is that so public records are any recorded data or information relating to the conduct of the public's business, prepared, owned, used, received, or retained by a public agency, or to which a public agency is entitled to receive a copy by law or contract. And again, I talked about the law being a little outdated, and this next part kind of shows the age. Whether such data or information be handwritten, typed, tape recorded, videotaped, printed, photostated, photographed, or recorded by any other method. And except as otherwise provided by any federal law or state statute, all records maintained or kept on file by any public agency, whether or not such records are required by any rule or by any law or by any rule or regulation, shall be public records. And every person shall have the right to inspect such records promptly during regular office or business hours or copy such records. So again, this is the presentation is great because it highlights the important things there. Any recorded data or information. So if it deals with City of Norwalk business, it is a public record. And again, with the devices, doesn't matter what device you use to send it. If it deals with the public's business, it is a public record. And then, as I said, the two ways that people can access public records in Connecticut are either records inspections or requests for copies. I'll just take a few minutes to talk about inspections. Copies is what you see much more frequently. But just know, especially for any of the city staff who are listening, if someone comes into your office, you're in the building department, and they say, "Hey, I would like to look at the file for 125 Main Street," that under FOI is a request for a public records inspection. The key thing with that is that there's no requirement that anybody has immediate access to public records, and that goes for inspections or for copies. The goal and what the law requires is promptness. So in that event, if somebody walks into your department in City Hall, and says, "Hey, I want to look at this file," you could tell them, "Look, I'm busy right now. I'm the only person in the office. I'm leaving, for the day in half an hour. Can you make an appointment? Can you come back on Thursday? Can you come back on Friday? Give me information about what files you need, and I'll go pull all the building files, and I'll have them all ready for you in a conference room, and you can come look through them." So if somebody wants to come inspect public records, that's their right. They can do that. But again, more frequently, you're going to get requests for copies of public records. An FOI request, someone's going to email you and say, "I want your emails. I want this report from the council. I want budget documents," whatever it may be. If somebody wants copies of public records, the law says they have to put something in writing. So, if somebody grabs you as you're leaving the council meeting and says, "Hey, can you send me this and send me that? And I want a copy of this, a copy of that," you could tell them, "Hey, put it to me in an email, please." Couple things about that. One, it's required, and two, I find it's helpful because you're working off of the same request. You don't want things to get lost in translation. You don't want to start trying to find something for somebody and you give it to them and they say, "That's not what I wanted. It's not what I asked for." If somebody wants an FOI request, if they call you up and they ask over the phone, or they talk to you in person, ask them to put it in writing so that you have a clear idea of what they're requesting. The law requires people to clearly identify the records that they're requesting. If you can't decipher what the request is, you can go back to the person and say, "Look, I'm not," if they say, "Give me all the firehouse files," I don't know what that means. Go back to them and try to get them to identify what the request is. I want the budgets for the fire department from 2010 to present. I want copies of all the emails from the people on the fire department building committee, whatever it may be. They need to identify the records that they're looking for so that you're able to go look and find them. So a couple things on there we talked about earlier, but you're not having to do research. You're not having to create records that don't already exist. I got a call from a police department a couple of weeks ago. A personal injury law firm had contacted them and said, "Can we have the list of everyone who's been in a car accident in your town in the last year?" Well, if any of you work for a police department, you probably know they don't have a list, and they don't add you to the list of people who got in a car crash when you get into a car crash. So in that event, in that instance, that the town told the person rightly, "We don't have that. We don't have the list." Someone asks you for a list of, "I want a list of the projects the city council is going to take on this year." You may not have the list, and you can just say, "Look, we don't have the list." In that police example, what happened is they ended up asking for the accident reports, for the year. So in this case, if someone asks you for the list of projects and you don't have it, they may ask you for specific information about a specific project, and then that would be something you would need to provide. So you're not creating documents that you don't already have, and you're not doing research and, you don't have to answer questions. It's about providing copies of records that you have. I like to say, as you keep them, as you maintain them. There's no requirement that people use a specific form to make an FOI request. They don't need to use any kind of magic words. They don't need to say under the FOI Act. If you get an email or a letter or anything where it's somebody asking you for a copy of public records, that is an FOI request in Connecticut. And one important thing to know about records requests is that it says in there about the right to receive copies promptly. There is only one specific time frame, and it's the first bullet point on there. Is it? No, it's not. It's not on there. But there's one specific time frame that you need to remember, and that's you have to acknowledge a records request within 4 business days. This is really super important because the way the law is structured, and again, it's kind of a little bit of an antiquated thing, but if you imagine back in 1975, people were all sending their FOI requests by mail. So this was put in the statute so that basically someone could confirm that the letter got to the person, right? So it requires you to write a response within 4 business days. So today, you could just send an email back to the person, hey, got your records request. You don't have to promise them anything. You don't have to tell them if you're going to give them the records or not. You don't even have to tell them that, you may not even have the records they're asking for, but you have to respond to the records request within 4 business days. If you don't, under the law, 4 days go by, the request is considered denied. They could file a complaint with us as soon as the 5th day. And believe it or not, there are people out there who will do that. There are people who are, kind of really like FOI hounds. They know it really well. They may have an axe to grind with the council or something like that, and they may be looking to trip up an agency. And that's one of the places where people will get tripped up. Even if you have gone and started to do the work, you started to pull the records, you looked through your emails, you may be doing everything right. If you don't respond to the person, it's considered to be a denied request under the law. So you want to make sure if you're not the one responding, the council president wants to respond on behalf of the council, whatever it may be, somebody gets the response back to that person who made the request. So once you've made the response to the request, that's where we talk about promptness. People need to get copies of public records promptly. And as it says there, promptness means, and this is kind of funny, so, the advisory opinion defines promptness as without undue delay, which is not really much better than saying you got to be prompt. But there were some factors in this advisory opinion that came out years ago that sort of, I always tell people, think of these because this is what we look at when we have an issue where somebody files a complaint and says, I made a request to the council, they weren't being prompt. This is what we're going to look at. Agency's workload, is it a really busy time of year for you guys? Maybe you're finishing up the budget and you're having a lot of meetings, and so it's really getting very busy at that time. It may take longer for FOI requests to get processed during that time. The size and difficulty of the request. If somebody wants years worth of emails, it's going to take longer than if they want a copy of one report that was done. So there's all these different factors that are taken into account. How big the agency is, staffing levels, all that kind of stuff. You're in a small town, you're the only person in your department, it may take you longer than a bigger city where there's more staff. The way to think of it is, and I always get a kick out of this because there's a part of the opinion at the end where it says something like, if you explain to people the time constraints that you're under and you try to reason with them, most people are reasonable. And if you make a records request and you explain to them, they'll be happy to know that you're working. And we know that's not the case with everyone. You can tell it's kind of written in a different time. Yeah, there it is. The commission believes that if an agency politely explains to a person seeking access to records why immediate compliance is not possible, that person will most likely understand and appreciate the agency's obligation to balance its duties as custodian of public records with its other duties. So I imagine there's a lot of people who are not necessarily going to understand, but if they file a complaint, what you want to be able to do if you have to come before the commission, if you want to show that you were working on it, you were balancing that FOI work with your other responsibilities, that you weren't ignoring it. You don't want to have a situation where you come before the commission and you say, well, I sent the 4-day acknowledgement and then I put it on the side of my desk and I didn't do anything for 3 months, and then I got a letter in the mail and said there was a complaint filed. So you may get big FOI requests. That's another challenge. There's really not a limit on how big of an FOI request somebody can make. If the city has records going back 30 years, they can make an FOI request going back 30 years. FOI requests could require, hopefully not for the council, but for staff, you may have to go search in the basement of the archives and pull old files and all that. But the key thing is you don't want to ignore it. You want to try to work on it. spend an hour a week working on an FOI request. If you got a request for, years worth of your emails on the council, we don't expect you to be up all night, trying to fulfill it, but we would want to see that you're devoting time to it, you're working on it, and again, you're trying to balance it with all those other duties and responsibilities. Couple suggestions, if you get a big request like that, again, you could always ask the person to narrow the request. Sometimes what may be helpful is tell the person, look, I can get it that much faster if you can narrow it. If you want 10 years worth of records, it's going to take me a couple months. If you want the last 2 years, I could do that by the end of the week, maybe. If somebody asks for like 15 different documents and there's 5 of them that you just have sitting on your computer and you can easily just give them to them that day, do that. The more you can sort of work with the requester to provide them what they're looking for. If somebody asks for a huge amount of documents related to a particular project, you could always ask the person, what are you interested in about this project, right? Maybe they don't need every single, email about, the improvements that are being made to the beach. Maybe they just want to know how much it costs. You can always ask the person, what are you really trying to figure out? What can I do to help you get the information that you're looking for? Sometimes if people don't know exactly what they're looking for, they make a big request because they know they can under FOI and they'll get it eventually, and somewhere in all those documents is going to be their answer. But you could always try to help them and say, look, what are you really trying to find out? And let's try to help you get what you need, and save time for both of us. So, an FOI request, sometimes people view it as kind of adversarial. Oh my gosh, people are gunning for me. There's something out there. They think they're going to find something. I would encourage you to try to work with the people who are requesting the documents. The key thing is are they public records? If they're public records, for me, they're public records for her, they're public records for her, for him. It doesn't matter if, I like to say, I know that there's nobody in the city of Norwalk that is ever difficult and ever gives anybody a hard time. Maybe in some other cities, we have people like that. But, even if it's the person who, is at every city council meeting and they're always talking to public comment and they're always asking a million questions and you're going, oh my gosh, him again. Even if that person makes an FOI request, you got to look at what the request is. And if they're public records, by and large, they need to be disclosed. We'll talk about the exemptions in a second, but don't let the requester get in the way of looking at what the request is. Last thing I want to talk about with processing FOI requests is the fees. There are no fees permitted in the statute for electronic records. So if somebody wants copies of emails, and they want them electronically, there's no charge for that. Same thing goes for PDF report or an Excel spreadsheet, any kind of records that are digital. There's no charge for that. Paper records, in the event you still have paper records, at the local level, you can charge 50 cents a page for paper records. And if the cost to fulfill a records request is going to exceed $10, so if somebody wants, let's say hundreds of pages from a building file in City Hall, if it's going to be more than $10 to make the copies at 50 cents a page, you can ask them for the money up front before you make the copies. It's not a bad idea if you have a big request, because what you want to avoid is, somebody makes the big request, you tell them, okay, it's going to be $275, and you never hear from them again, and you have this big stack of papers sitting on your desk that never come to get collected. So that's about fees. We talked about how long you have to fulfill a request. So next we'll talk a little bit about the exemptions to FOI. To your question, what is not FOIable? So when I read the definition of public records earlier, there was a piece in there where it said that everything is a public record except as otherwise provided by any federal law or state statute. And what that means is, if there's another law in the books that says don't give something out, that'll always override FOI, whether it's a federal law, FERPA and HIPAA are two of the big federal ones people know. But the challenge with FOI is that there are all throughout the statutes little exemptions that are added in every single year at the legislature. They're always trying to tuck something into a new bill, or there's a new agency created, and oh, by the way, it's not subject to FOI. The example I always give, not to pick on teachers, I love teachers, my wife is a teacher, but there's a state law that says the performance evaluations of public school teachers are exempt from disclosure in Connecticut. So if you're a police officer or a firefighter, somebody can get a copy of your performance evaluation. If you're a teacher, they cannot, because there's a law that says that. So if there's ever a law that says any information doesn't get disclosed, that'll always supersede FOI. And then in our law, and some of this is in the little handout that I gave you, there are exemptions. So when they created FOI, the lawmaker said, yes, we believe in transparency and we want everyone to have access to these records. But there's got to be certain records, certain information we don't have to give out. There's a good public reason to not disclose certain information. When FOI was passed, there was about 5 or 6 of them. Now there's something like 25 or 26 exemptions. And again, kind of like the programs every year, they're starting to consider adding more and more. But I'll go through some of the more common ones that we see. The first is there's an exemption in the law that says you don't need to release anything that is considered to be a preliminary draft or notes. And as I mentioned earlier, for notes, the things you should be thinking about are, notes you take during a meeting as a memory, things you write down on the margin of a document, something like that. This is not meant to be that you can go home and you can type up everything you think about the meeting and send it to 10 people and say, well, those were my notes. Notes really needs to be something that you're keeping for yourself. You're not sharing, maybe it's helping you to remember what happened at the meeting, that kind of thing. Preliminary drafts is a tricky one. I'm not going to lie. This is an exemption where, in a lot of the exemptions, somebody in a training recently said to me, well, it seems like a judgment call. And there are a lot of things that are a judgment call. And that's why we have an office full of attorneys. When someone files a complaint, that will look at the complaint and look at the law and do the exemptions apply. So some of these are going to be hard decisions to make. But with preliminary drafts or notes, preliminary draft is meant to be really it's kind of the staff work. Before it comes to the council, you may ask someone in town, in City Hall, to develop some kind of report on a certain project. There may be different iterations of that report that go back and forth. Somebody in Public Works brings it to the Public Works director, he gives input, it goes back to the person, and there's all these changes that are being made. But once it's ready for action, once it goes to the council for some sort of decision to be made, it goes to the mayor. You're considering a town hall reorganization plan and shifting job responsibilities, and people are working on it, but then it gets sent to the mayor for his consideration. Once it becomes ready for action to be taken, it's a public record you would need to disclose. People need to be able to see what our elected officials and our people that work in City Hall, what they're using to rely on their decisions. But it allows for a little bit of confidentiality in the process leading up to the creation of that version of the document. Another thing that's exempt from disclosure under FOI, certain records and personnel files. Some people think, personnel files are totally off limits. That's really not the case. The key thing is that you don't need to release information that would pose an invasion of personal privacy. And like so many things in FOI, one thing that's helpful about the law is because it's been around for 50 years, there's a lot of precedent, there's cases, there's, court cases. What the courts have said, the Supreme Court said, is that for something to be an invasion of personal privacy for a public employee, it needs to be highly offensive and not pertain to a matter of public concern. That second part, if you think about it, there's really going to be a very limited amount of documents relating to public employees that are not of the public's concern. The public has an interest in knowing, how much our public employees are paid. Are they doing a good job or not? There's a disciplinary investigation and somebody's found to have, done something wrong. They may not want that information released. It may be embarrassing to them. It may hurt their reputation, but that's not what the standard is. The standard is it needs to be, again, not an invasion of personal privacy is something it pertains not to a matter of public concern. There was a case last year in a Old Saybrook Police Department where there was an officer who left the department as part of the offboarding. They did an exit interview, and in his exit interview, he had a lot of comments about the chief that were very critical. He basically said the chief doesn't know how to do his job. Chief wasn't too happy with that, as you can imagine. And then somebody came along and made an FOI request for a copy of that police officer's exit interview. The town said, we're not going to release it because we believe it invades the chief's personal privacy, right? It's talking about how bad he is and all this stuff he doesn't want released. The commission said, no, it's a public record. There's a public interest in knowing, the job the police chief is doing. As I said earlier, you can challenge our decision. Old Saybrook took us to court over that. The court agreed and said, no, a record that reflects, how a public employee is doing, good or bad, is a public record that needs to be released. So the types of personnel records that you probably would not disclose, certain things dealing with medical issues, it could be, family issues that come up in the context of work. If you're sending an email to your boss about, your kids are sick and this and that, and you need to take a day off, those types of records could be things that would be exempt. But by and large, if it deals with, the conduct of your employment with the city, it would be a public record. In the event that you get a request for personnel files and there is a privacy concern, you believe, there's some medical information in there, or there's something in there that would be an invasion of personal privacy. The law says that you go to the employee whose file it is, contact them, and then they have the right to request that you don't release the records. And if that's the case, you don't release them, and then if the person wants to pursue it, they would have to file a complaint with us, and the commission would do, and this is what we do in records cases, what's called an in-camera inspection of the records. So one of our attorneys would basically look at them and would say, okay, according to the law, are these exempt from disclosure or not, based on that precedent I said about the invasion of personal privacy. So a couple other exemptions that I want to touch on. Some of these are similar to what you saw in the executive session earlier. So there's an exemption for documents that would pose a security risk if they were to be released. If somebody wants to, schematics to the police station, the police department may say, gee, that doesn't sound like a good idea if we give those out. If there's ever an issue where you think releasing something would pose a security risk, you get an FOI request, you feel that there's reasonable grounds that, giving out the information would result in a security risk. It could be, harm to a person, it could be harm to a building, whatever it may be. At the local level, the process is you go to the state police and you seek what's called a security determination. So you would go, the chief elected official for the town would do it. So your mayor would go to the state police and say, we got this FOI request for these documents. We think there's a security risk, and then the state police would review it. And then if they agree, you don't give out the records. And then if somebody challenges it at the commission, the state police would come with you to a hearing potentially, and they would defend the decision and explain, in their, based on their expertise, why those documents pose a security risk. We talked about attorney-client privilege. So again, you seek a legal opinion, something like that. You're discussing your settlement strategy for a lawsuit. Those could be protected by attorney-client privilege. Those won't need to be disclosed. Any records relating to collective bargaining strategy or negotiations. So, if you guys are emailing back and forth with the union president about, what you're proposing and, percent raises for the contract and things like that, collective bargaining records, those could be exempt. Records relating to pending claims or litigation, as I mentioned earlier, things talking about, strategy with a lawsuit. There's a lot of exemptions for law enforcement records. I won't go too much into it, but, basically there's certain types of information from police reports and police files that don't need to be released, including if it's information that would be prejudicial to a pending law enforcement action, if it would compromise an investigation. If it were to be released, there's information that police departments, don't need to release. There's an exemption for trade secrets, what we call trade secrets. This is sometimes where the city, you may be doing business with a vendor, and they may share certain information with you as a vendor that they don't share publicly. Maybe it's proprietary pricing information, or it's some kind of, proprietary information about their products, again, that they don't share publicly, and that they would suffer some sort of economic harm if they were to release it. So they're giving it to you for a limited purpose, but it's not yours to go off and distribute in response to an FOI request. But really, FOI in Connecticut is really, in favor of disclosure. The whole way the statute is structured is basically, and this is often what I tell people, if they call and they say, to your point, is this FOIable? Do I need to release this? If you don't believe you need to release something, you really should be able to point to somewhere in the law where it says that, either some other law on the books at the state or federal level that says, no, this is protected information, or an exemption in our law that you think is applicable. One of the biggest challenges that we run into in Connecticut is there's no exemption at the state level for what's called personal identifying information. At the federal level, there's this exemption for, people are doing business with the city. They license, they dog licenses, for example, that this is a real thing that happens. So let's say when you apply for a dog license, you put your name, your address, your email, your phone number, all this, right? The breed of dog, and all, it goes all onto the thing, and they process it. Those are public records, and there's no exemption that says you can redact, the email addresses and phone numbers and names of people who apply for dog licenses. I've seen now towns are starting to run into where people are, I think, getting wise to this, realizing that, towns collect a great deal of information. And again, unless there's an applicable exemption, there are some exemptions for certain types of information. For example, there's another one of these is information about people who attend senior center programs. Years ago, there was a concern about that. They put in an exemption. If any of you, work at the library, there's an exemption that says you don't need to release information about individual library card holders. I can't go and ask what books did you check out. That's something that's exempt from disclosure under FOI. But there's a lot of information and that cities maintain, and most of it is public. Again, unless there's a particular law, on the books somewhere that says, do not release that information, generally you would need to release it. So that's kind of, I want to be mindful of the time. That was a quick overview of the records. Anyone have any questions on FOI requests or dealing with records requests or anything like that? Yes.
Does the requester have to like give their full name and address and any requirements for that? So they do like an anonymous request?
So this comes up from time to time. The only requirement is they have to put something in writing. So if they don't want to give you their name, you could ask them, but not giving their name would not be grounds for you to deny, the FOI request. Like I said earlier, you have to really look at the content of what they're requesting. So, it doesn't matter who the requester is. It matters, are they public records that the person is asking for? Again, you could certainly ask them to identify themselves. Sometimes, cities will have a form that they ask people to fill out to make an FOI request. You can have the form, but you just have to know if somebody doesn't want to use it or they leave their name blank, that isn't grounds to deny the request. A good question.
So, can I ask a question? Sorry. Just, can you repeat it?
Oh, the question was, do people have to identify themselves when they make a records request? And the answer is no, they do not.
There any kind of requirement for documenting when somebody has submitted a FOIA request and what the outcomes are, instead of kind of like, he's done the state and responded to them.
So the question was, do you need to document FOI requests when you receive them, when you respond to them? There's no requirement to do any of that. I would say if you get a lot of them, it's not a bad idea, because the dates are important, especially making sure that you get the acknowledgement within the 4 days and that you're being prompt. But how you process your FOI request is entirely up to you. We don't police that. Just that you're doing it.
So, I'm sorry. The reason I'm asking, so if somebody sends a FOIA request to like 20 people or the entire council, what's, I'm saying, like, who's responsible for that? It comes down to nobody responded.
So the way I think of it is, if the way it works is the agency that the person is requesting the records from is ultimately the one that's on the hook. So the response could come from the mayor, the city attorney. Like, it doesn't necessarily matter who the response comes from, but the person that is the buck would stop with the board. And it's the same thing with with minutes. Sometimes people ask about that. Let's say you finished the minutes and you sent them to the or you sent them to the recording secretary, but they never got to the clerk. Everything to do with FOI, it's always the agency involved. So if nobody responds, it would fall on the council. So they can have anyone they want to respond, but they should know if an FOI gets sent to the full city council, somebody needs to respond, or else the full city council would be the ones that would be on the hook.
So I would say as individuals, if you get a response, or if you get a request, you said it's Starling, and then Starling.
Yeah, you can funnel them. So.
But if you not respond, I would, as an individual, be responsible for the fact that you did the word. It's my responsibility to let them know. I'm trying to say, yeah, sure, right. You would know that, I would follow it.
Yeah, or you can always you can make sure the people get CC'd on the response or something like that. But you want to the 4-day thing is is very important. You want to make sure that you get that out, because as I said, what happens unfortunately sometimes is especially in political season, which we're just through thankfully, but people will be on the lookout for this type of stuff, and they may send you an FOI request, and you may think, well, gee, I don't have anything, I'm not going to respond to them. But if you don't respond, they could file a complaint, and then there's an issue you got to deal with. Any other questions?
It sounds like respond in 4 days and then ask your attorney, you have to do it. Make sure.
Sure. I mean,
Make sure it's FOI.
yeah, I mean, that's the thing that is tricky, is that the different exemptions there. The way I'd like to think of it is, there's a lot of records requests that are going to be pretty straightforward. The ones that are more sensitive, consult with your city attorney, because they're going to know the different exemptions and the statutes and all that. But again, whenever I'm on the phone with people and they're asking, do I have to give this out? As I always sort of push back and say, well, if you don't think you do, kind of give me an idea of what you're thinking, because you should have an idea. Again, not that the person's going to file a complaint. You may say no, and they may just say, okay, I'm not going to get it. But just imagine when you say no to somebody, okay, if they're going to challenge me on it, I need to have something I can point to other than to say, oh, I don't want to give it out. You need to have an idea of what it may fall under. And some of these, as I said, are judgment calls. We get cases in the office where one attorney thinks one way, one attorney thinks the other way. So some of these are hard. There's not always going to be a right or a wrong answer, but you want to just be prepared and be thinking, okay, I'm not going to give this out because I think it's a personnel record that's an invasion of privacy, or I'm going to give these emails, but not these ones, because these ones are attorney-client privilege. I was asking for legal advice about something. Yes.
If someone requests submits an FOI request to someone on the council for records that they are not the custodian, for instance, if someone asks a particular council member for police records, right? Is it an appropriate response for them to say, I'm not the custodian of the record? Or do they have an obligation to forward it to someone in the police departments so that they can respond?
No, there's no obligation to forward it. That's a very good point. These are your records. So if, you may get a lot of things from constituents because they know you on the city council. You could forward it if you want to, but we actually have a case. It was involving the first selectman where somebody made an FOI request to a first selectman for, records of another department. And in some of these town halls, small towns, it gets a little silly because it's like one department is across the hall from the other, but the way it works is it's the person who receives the request. So if you get a request for, Board of Education records or police records, you could tell the person, please make that request directly to the police department and they can help. Any other questions? Let me give you my phone number. It is 860-566-5682. And then my email is Russell, RUSSELL .Blair, BLAIR @ct.gov. And again, please, if you get an FOI request and you're not sure what to do, reach out. Even if we talk and we disagree, I'd rather have a conversation about it, and try to give you, the best advice I can. Or as I said earlier, the benefit we do have is we have 50 years worth of cases. So chances are, absent some of the newer stuff with the virtual meetings and things, those are a little bit untested, but there may be a case that we can find that deals with this issue that you're dealing with that can give you some guidance about, what the commission thinks about a particular issue. But, thank you to everyone who attended in person and on the Zoom. Some great questions. And again, I'm always available to help. I want you guys to feel comfortable doing this, and I don't want it to get in the way of the important work that you're doing. Make sure you can take care of FOI, but it doesn't become this overly burdensome thing. Oh yeah, sorry, I if anyone is there a chat? I don't know if I can.
Just ask them to raise their hand.
Oh yeah, if anyone on the Zoom has a question, we can do raise a hand. Going once. Got a lot of people on the Zoom.
Yeah.
Did you have one more? Somebody thought I heard it. No. Okay.
Thank you. Oh, wait a minute.
Oh, we got one. Okay.
Sorry, I had to be that guy when you all put your coats on. I'm sorry about that. Do you guys do any training specifically for land use agencies? Because if FOIA requirements are a little different than like council folk.
So nothing really. I mean, I'm always happy to come out to anyone that'll have me. So nothing really. The presentation kind of covers everything, but if you have specific questions, I'd be happy to answer them if you want to email me or give me a call, because there are additional requirements in the land use statutes that are not under FOI, but I do know about some of them because I get questions about them.
Gotcha. Thanks.
Okay.
Are we adjourned? Are we adjourned? Are we done, Mr. Blair?
Yeah.
Thank you very much. We were trying to figure out what that was.